Hi, and welcome to our first panel discussion of this semester. My name is Elizabeth Sandberg. I'm one of the 3 instructors for conflicts. We have Jason Keller is in the middle of the room there, and this is Vivian Turk. Please be advised that this panel discussion will be recorded. Okay, so for those of your classmates who can't make it today, they can watch it in about a week or so when it gets digitized. For my classes, I'm going to send around a sign-up sheet, so make sure that you put print your name, please, and also put a check mark or a heart or something by which class you're in, the 9 o'clock class or the 10:30 class. I have uploaded on Moodle an assignment which is due on Tuesday at noon sharp. No late submissions, okay? Please pay attention here and give our panel your attention and appreciation. And Vivian, do you have any announcements? Vivian has extra packets for you in case you didn't get one. The city has been very generous. I see a couple of hands going up there. All right? And then make sure that you sign up on the attendance sheet. All right? So without further ado, Vivian, do you have any announcements?
No, actually.
Okay, good. So let me introduce to you Elizabeth Savage, who is the Director of Human Services and Rent Stabilization in the City of West Hollywood. And she will, I think, direct this meeting.
Sure. Thank you. We're very pleased to be invited to be here tonight, this afternoon, wherever it is. Working a little much. This originated from a conversation that I had with Professor Sandberg. She said, I'm doing a class on conflict. Do you have any thoughts? Never ask me if I have thoughts. I always do. I said, there's an intrinsic conflict between landlords and tenants. Landlords are in a business, and tenants are at home, and may perceive that their home interest may supersede that the rent needs to be paid. So we're here to talk to you about that, where conflict can develop out of that. Is it intrinsic or not? Does it have to be? What does that relationship look like? I had a tenant in my office last week who, when I was saying the contractual relationship, she looked at me baffled. She said, well, I've lived there 25 years. Yes, it's still a contractual relationship. It's got a legal framework to it. So today, we have, in addition to my presence here today, we have Mark Lehman, who has been a judge pro tem in landlord-tenant issues, an attorney for a while, and been on the planning commission of the city of West Hollywood, and is a business and real estate attorney. He helped form the city's first general plan. The city of West Hollywood was formed in 1984. Is there anyone here who's in public policy, urban planning interests, or local government interests? No, transdisciplinary. Okay. I want to also ask, is there anyone here who is a tenant? Anyone live where someone pays rent? Okay. Anyone live in a single-family home where you don't pay rent? And the rest of you don't live in housing? Okay. We're not here to help with homeless services. The city is very proactive on that as well, but you're in the wrong jurisdiction at this time. So my background is that I'm the Director of Human Services and Rent Stabilization. I have 4 divisions. I've been with the city 20 years. I've been in the housing capacities for the last 7. It is the most rewarding work and interesting work. Different issues come every day. People bring different ways that they've messed up things. And so we're here to talk a little bit about that. Also, we have Gail Sains, who has been a litigator for 26 years. She serves on the Rent Stabilization Commission and was part of the decisions in the cases that were assigned to you. So you have some real examples. They were redacted for people's privacy, but these are real cases that happen at the commission meetings. She's been a Rent Stabilization Commissioner for 6 years. The Rent Stabilization Commission meetings are televised. You're welcome to go to weho.org, and you can actually look at these cases being heard. We have the dates are on them, on your assignments, so you can actually watch the transactions of what occurred. You can see how the landlord and tenant each presented their case or did not, and what the commission struggled with in that part of it. Gail will be talking about that some more as well. So for some general background, I want to ask Mark to start. I'll give some background on the history on the city of West Hollywood and rent stabilization, a little bit of what that is, and then Gail will talk about the cases.
Good afternoon, everybody. Hello, can you hear me? Yeah, Mark Lehman. My job here is basically sort of set the stage for this discussion. And excuse me if I'm going to say things that you already know about. I'm going to presume that you don't have a lot of familiarity with landlord-tenant relationships. So my job basically is to sort of give you the basics. So, and the basics are, I think we start because we all need and want a great home to live in. Where we can live hassle-free. It's probably finding a home is one of the most significant decisions we make. Our housing costs are often one of the biggest parts of our daily budget, if not the biggest part of our budget. Our home is usually where we spend a lot of our time. We want it to be enjoyable when we're at home. That being said, as many of you probably may have experienced, a landlord-tenant relationship is not always simple, and sometimes can be a source of conflict in daily life. My focus is, in my context as a lawyer with a fair amount of real estate experience, to provide sort of an overview of what the landlord-tenant relationship is about and to maybe identify a few sources of conflict between the landlord and the tenant. The first thing I think to start, it makes sense to start, is I decided I want to rent an apartment. I need a place to live. Where do you start? I'm going to assume tonight that most of you, if you're going through this process, are probably looking for an apartment as opposed to a home. There's not that many distinctions here, but it's probably more common that you're looking to rent an apartment, especially if you're young and a student. So let's also assume that you've decided to rent an apartment for yourself. Because I don't want to get involved with roommate issues. Those are kind of complex, and I don't think we've got time to get into that. So you usually start by thinking about what neighborhood do I want to live in. And you try to find a unit, an apartment that is attractive to you, that works for you. Of course, probably most important, and hopefully you'll think about it in advance, because it's very important, this whole process is your budget. I mean, how much can you afford to pay for your apartment? Obviously it's important on lots of levels. The landlord may not be interested in you as a tenant if he sees pretty quickly you can't afford the rent. And from your viewpoint, obviously, too, you've got to be able to pay the rent. If you don't pay rent, then you've got issues with the landlord. So let's assume you're starting that process. You probably know better than I. There's lots of different ways to do that. You can go online, and there's all kinds of web services that provide listings for apartments. West Hollywood may be kind of unusual. West Hollywood has listings both online and its own city website. And if you go to City Hall, they've got listings of wonderful rent-controlled apartments and non-rent-controlled apartments. You may just hear about an apartment from a friend. You may just be driving down the street and see the for rent sign. So there's lots of different ways to potentially come across a potential apartment that you want to live in. So what do you think about when you're looking at an apartment? You think about, is the apartment the right size for you? What is the rent? Can I afford it? What kind of amenities does the apartment have? Does it come with parking? Does it have air conditioning or heating? Does it have a kitchen that works? I mean, those are the basics. I mean, what do you need? And assuming you're then going through this process and you find a place that you think you might be interested in, you will probably start by contacting either the landlord or some representative of the landlord. A lot of buildings have managers who handle all of this detail. So you go and you contact the manager. Maybe you set up an appointment to actually go look at the apartment. You go look at the apartment. Maybe you like it. A good idea in this early on part of the process is for you to really, I'll use the term inspect the apartment. Know what you're going to be renting. Take a good hard look at it because this is going to be your home, and you don't want to be surprised later on with what may or may not work and what may or may not be offered. So I think inspecting a unit is a really good start. Make sure you understand how much the rent's going to be. Make sure you understand, is parking included? and a lot of other basics. What amenities are provided or not provided. Who pays utilities? That's a key. Some apartments, water, electricity, etc. are included, and others you have to go out and you have to sign up with the local utility and get your own account and pay for your own utilities. These are important things, I think, to look at up front. Other things you may want to do at the same time is kind of take a look around the building or the complex. Get an idea, is this building well maintained? You can probably get some feeling for it just by walking around, because that's going to be crucial to you in the next years that you're living there. You want a place that you're going to be happy living in, that's going to be a nice place to live in. The other thing you may want to do if you've got time and people are open to it is to talk to some of the nearby residents and neighbors. Sometimes people are willing to talk to you, and if they are, you might want to ask a couple of questions. And what's the landlord like? How well is the building maintained? Do you have any problems with neighbors? And I'm sure you may have experienced that, but sometimes if you live in an apartment complex, you have to deal with neighbors that may not be the best neighbors. They may be unruly or loud or problematic. So it's good to try to find out as much of that as you can before you even rent an apartment. Next step, assuming that you've decided you really like this place and landlord or the manager decides they want to rent to you, what happens next? Usually there's some sort of a rent application form that they will want you to fill out with all the basic information about you. Probably the next thing they're going to want to know is, do you have a job? What source do you have of income? They want to know that you can pay rent. They may also ask you to fill out a form to authorize them to do a credit report. That's also for the purpose of them discovering what your financial means are. How are you going to be able to pay that rent every month or not? And also, credit reports will sometimes tell whether you've got a history of problems in that area. So landlords do that, and it's actually appropriate, legal for them to do it. And I think you should be prepared and understand that process. So the next thing is the rental agreement itself. And in most instances these days, people will provide you with a written rental agreement. Sometimes we call it a lease for you to sign. You do hear about it. It sometimes happens more informally where there's no written agreement, but we still have an oral agreement. I'm going to rent you this apartment, and here's what the rent is, and et cetera, et cetera. From my perspective, it's always better to have a written agreement. And it's important for you as a potential tenant to really read it and understand it. I mean, all of us, even those of us that are lawyers, sometimes you see a document and you don't really want to read it. It's too long, or you may not want to take the time. But it's really important because that's something that's going to govern your living relationship for a period of time. So what should you be looking at in that rental agreement? Obvious ones: what's the amount of rent? What day of the month is the rent due? Is the landlord going to require a security deposit before I move in? And how much is that going to be? And another real important thing, and this is probably something you talk about with them before you even get to that point, is how long is the term of this lease going to be? Is this, am I renting for a year? Am I renting for more than a year? Or is this just a month to month where I pay on a monthly basis, but it's, I've got no long-term commitment needed as a landlord? Those are basics. I'm obviously not getting into a lot of detail, but those are basics that are covered in a lease or a rental agreement. I also want to kind of just touch on basic tenant rights here, because just for now we're going to get into the next issue, which is sources of conflicts. And I think we start by what basic obligations does a landlord have, and do you have? Landlord does have an obligation to maintain sort of a safe, and the term we use in law is habitable environment for you to live in. I mean, I'm not going to get into the definition of habitable, but it's because that's a legal discussion. But it's got to be a place that provides basic services and is comfortable. Along with that is if you've got hot and cold water, which you hopefully will have in an apartment, it should be working. If there's air conditioning, it should be working. We hopefully are not dealing with a situation where you have leaks If there are leaks, the landlord should repair the leaks. I mean, those are sort of the basics of what we're dealing with. But that being said, it still comes about that we have problems when you move into an apartment. You know, I'm assuming some of you have probably experienced some of this. You're in an apartment and the landlord doesn't maintain it. You have problems. What are the sources of that? Well, services and amenities we talked about. You've got a lease that says you're going to have a parking spot, and all of a sudden, the landlord tries to take the parking spot away. Or you've got rats in the apartment, or you have a situation where your utilities have been turned off and you're not the one responsible for paying it. So you could have problems with your neighbors, as we talked about before. Maybe you've got an next door neighbor that likes to party a lot, and you can't sleep and you can't study. What do you do? I think the first thing that I was going to suggest to you is to educate yourself on what your rights are as a tenant. That's really important. And that education, I think, varies depending upon where you're living. You know, there's a resource that is sort of a statewide resource that I was going to refer you to, and we didn't include it in the materials. But the state of California has, through their Department of Consumer Affairs, sort of a California Tenants Guidebook with all the good basics. And I'll probably leave a copy of it here for you all, and maybe a link.
Sorry to interrupt. For my classes, I've got that uploaded on our Moodle class.
Oh, great.
If anybody else needs it, it's the 2012 version.
Yes, 2012. Jill revised July 2012.
So I'll go through and transfer so that
That's a great resource. It really gives you good sort of step-by-step on this whole process, as well as the conflict side of the process. And frankly, when I look at it, even as a lawyer, it helps me because, you know, like everything else, there's a lot of law, there's a lot of regulation, and you're probably not going to know it all. But on the other hand, do your best to give yourself sort of an idea and education about what your rights are as a tenant. And we'll be talking later on, some communities really deal with landlord-tenant relationships more seriously, well, maybe that's not the right term, but they have it as a sort of a basic tenet of what their community is all about to protect tenants' rights. Some communities do and some don't. West Hollywood is probably on one end of the spectrum where the city was formed based upon tenants' rights. On the other hand, we have cities like Glendale and Burbank that don't have any rent stabilization ordinance whatsoever and may have fewer resources for tenants to utilize when there's a problem. And I think that's important for you to understand when you move into a community, and if a problem happens, know what your local community is all about, what kind of rent laws are applicable. That book that I referred to, by the way, is probably a good one because it's a statewide book. It doesn't deal with the specifics of West Hollywood or another city like Santa Monica that has rent control. It deals with it on a general statewide basis. So I think it's a good idea to educate yourself about what your rights are, you know, as a tenant. So the next question is, you have a problem, what do you do? And I guess what we're talking about today is trying to deal with conflict avoidance, I guess, or resolution. And my guess, first advice, and probably pretty obvious, is if you do have a problem, the first thing to do is to be courteous and to communicate clearly in sort of a business-like manner with your landlord, your manager, or whoever else is involved. I know that sounds like a given, but these are touchy issues. You know, you're living in your home and your water's not working, or it's 100 degrees out like it's been this week and my air conditioning isn't working, and you may not be very happy. That being understood, I still think to start in a sort of calm and business-like approach with your manager or your landlord is always a really good idea. You don't want to elevate the conflict between you and your landlord. I think the second thing is to very clearly communicate what the issue is. I know that also sounds super basic, but explain exactly what the issue is, because they may not understand. And you want to, if it's a specific issue, that's what you want to be repaired or resolved. So be very specific about what it is, and you may want to even put it in writing. I mean, these days we communicate a lot by email. use email if you have an email address for your landlord or your manager, but communicate clearly and specifically as to what the issue is, and make sure you speak to the right person that can deal with this issue. You know, complaining to a neighbor doesn't help. Go to the manager, whoever the responsible person is, and make sure they understand what the issue is, and deal with them sort of a one-on-one, fair and reasonable way. As you'll find out later, some communities like West Hollywood have some really wonderful resources when these kind of conflicts come up. Let's say, for example, you do have a problem with a landlord who's not repairing, and you don't get any resolution of it. You try your best, and you just can't get the landlord to repair this problem. He just won't do it. What do? There's a lot of different avenues to go in that circumstance. And state law deals with that, and we're probably not going to get involved in the details of that here because that's a whole class on landlord-tenant law. But what's wonderful about some communities like West Hollywood is West Hollywood set up a mediation process, which I think that Elizabeth will talk about, as sort of an intermediary step before you get into a real heavy-duty conflict, go to court, and so forth. As you may know, if there's a problem with landlord-tenant, it ultimately will end up in what we call unlawful detainer court. I actually sat as a judge pro tem in that court for a long time, and all that court does is deal with landlord-tenant disputes. And it's not a very pleasant situation, but West Hollywood said we'd rather avoid that if we can. So they set up these mediation panels and require landlords and the tenants to participate in it. It's a wonderful resource. Some communities have it, some others don't. Another resource I was going to suggest to you is, if you're in that kind of a circumstance, do a little bit of research and see if there's any local organizations that help with landlord-tenant rights. There are quite a few in Los Angeles, and some of them are really wonderful organizations. Some of them will even go so far as to defend a tenant in court if it goes to a dispute, especially if you're a low-income person. Find out what those organizations in your community are. There's a few that I can mention. There's one called Housing Rights Center, another called the Fair Housing Council. But look and see if there's any tenants' rights organizations out there that can help you. So that's just sort of setting the basics and the sort of framework of landlord-tenant conflict. And I guess I'll turn it over to you, Elizabeth, and take it from there.
We're recording, so I want all the other students to be able to get this. And I really want to beg that we'll ask questions at the end, because you're going to get quite a bit of material right now, which I want everyone to get a chance for. But thank you. So at the City of West Hollywood, one of the reasons we're here is that we bring you a microcosm, almost like a laboratory, of how to resolve what could be an awful conflict. If the landlord is refusing to do repairs, you're a tenant, you're trying to pay rent. You say, I'm not going to pay that rent. Well, you have a legal obligation. It has nothing to do with the repairs. So the City of West Hollywood, there's a lot of education and resource that's put into this. Let me give you some background. The City of West Hollywood was formed in 1984. Previous to that, it was unincorporated Los Angeles County, which means that it did not have local governance. It had county governance. There are 5 supervisors, as you likely know, and they have millions of people under their jurisdictions, each of them in their districts. And so Los Angeles County had rent control, but it was starting to go away. And without rent control, which was needed because there was very high inflation in the 1980s, that is, that interest rates were at 8 to 10 to 12%, and inflation was running into double digits. So that the costs were going far, and the landlords wanted to get more rent. They also, in some cases, were using the situation to have rent increases. Some landlords in non-rent controlled areas were doing rent increases 3, 4, and 5 times a year. That's a problem. That means that people could be displaced. They could be losing their habitability and their right to a safe and consistent place to live. So So a groundswell occurred, mostly from senior citizens in West Hollywood, that helped form the city. It was also formed with a strong care and commitment about gay and lesbian rights. And so between the two, finally, there's a whole formal process that occurs, but a vote occurred on a county ballot, and the city was formed in November of 1984. So we're having a 30-year anniversary. Right now, the city has 34,000 residents. The city is 80% tenant. That would tell you why it was such an important issue. And there are 16,000 rent-stabilized properties in the city. Rent-stabilized properties are from the year 1979 and older, due to some laws that have come about since. So there's about 24,000 residential homes, houses, apartments. Of that, 16,000 are rent-stabilized. The rent stabilization division receives about 9,000 contacts a year. We have a population of 34,000. So people know they can call us and they're well served. Of those 9,000, 60% are tenants and 40% are landlords. Now they're in a business, you think they have a lot of resource, but there are some long-term mom and pop tenants who have smaller properties. Most of the buildings in West Hollywood are 40 units and under. They're not larger hundreds of apartments in a complex. And those mom and pop, old school kinds of property owners can run into a problem and really not know what to do from a business standpoint. So 40% of that 9,000 points of contact can get help from us as well. It is important under state law that, and under the city's law, that there's fair administration of what was passed in November of 1984, which is the Rent Stabilization Ordinance. That ordinance preserves rents. It does some market control of rents in accordance with some complex laws, which I won't detail you with unless we have questions later on it. But the regulation of rents became important. However, that has to be balanced under the state of California's Constitution, that there be a fair return for landlords, that there cannot be an unfair taking. So in other words, the role of government is that it cannot impose a long arm and push down one segment in an unjust way. The legal system cares a lot about justice in that respect. So there's a lot of laws. The state laws that are in this book are statewide, and the exceptions are in local jurisdictions. So if you're in the Los Angeles city, or the city of West Hollywood, or Santa Monica, that rule, those laws can prevail over the state law in some cases, but that interplay is complex, and I'm really religious on those things. The other thing is that we get a lot of the questions. The main question we get is people who are in trouble with evictions. What Mark set the tone for you with is these are the details people need to be aware of. But if you're not paying your rent, that's a cause in the legal relationship for you to be evicted. And if you can't pay your rent because you don't have the money, you're stuck and you will end up through an eviction process. If you are a nuisance tenant, and it has to be proved, and there's a high threshold for that, meaning you party every night, and you throw the furniture around, and you break the windows, and, it has to go into a real severity, then that can be a cause for eviction as well. But a lot of, 1.9 square mile city, 34,000 people, 16,000 rent-stabilized apartments, there will be a few disagreements. Some of those disagreements occur landlord-tenant. Some of them are neighbor to neighbor. So we put in your packet the free mediation service and more detail on what mediation does. And there is, separate from landlord-tenant mediation, there is neighbor-to-neighbor mediation that's needed, especially the main issue that comes up for people in noise issues. What you view as noise is not what someone else views as noise. You can roller skate on the ceiling above somebody, and that person will be annoyed, but the real resolution of that isn't going to happen through rent stabilization ordinance. It's going to happen through communication, and often another party is needed to do that. There is a process when the housing services that you've described are not provided as required. When you move in and the water's not working, and it's not working for some length of time, that's a health and safety issue, so code compliance would come in. But if there's broken window screens, the door lock doesn't work, the other commitments for housing services are not in place properly, the tenant has a mechanism by which they can file for a rent decrease. That doesn't necessarily cure those problems, but it does put the landlord on notice that the city is involved. And so what happens is that a tenant can file for a rent decrease, and we have given you the Hearings and Remedies Guidebook, which describes some of that process. They can file for that, and the first thing the city does is send a letter to the landlord and tenant saying a rent decrease has been filed. That alone wakes up the landlords who do care and didn't realize there was a problem, or didn't quite get to it or something like that. That wakes up a lot of them. So rent decrease hearings are often withdrawn. If, however, that is not done, and the landlord disputes it in some way, it can go to a hearing. The rent decrease can be awarded or not by a hearing officer, specific in accordance with the rent stabilization laws and regulations. And then if that dispute continues, it can go to the Rent Stabilization Commission, where Commissioner Gail Sains serves. The process is that once the rent decrease is filed, every decrease, not only is that letter going out that wakes the parties up a little bit, the city mediator calls both parties and tries to come to a resolution. The city mediator handles 1,500 situations a year. That is a dispute resolution process. That is a conflict remedy. And we actually get a couple hundred hearings that actually go to the hearings officer, and of those we get between 15 and 30 that actually go to the commission. So what happens is that this administrative method, this way of resolving conflict and dispute works. It helps to get the parties to talk to each other, to resolve the housing service issue, that is the obligation of the landlord to provide per the initial contract that occurred. And then when that doesn't happen, it goes all the way to appeal. Does it come out right all the time? You will hear from Gail some thoughts about that as we've presented the two cases to you. So that's a little bit on the city history and the department, and this was needed because the market forces caused it, but on an ongoing basis, whether in an inflationary period or a recession period, the stability of the community was a commitment of the city council, and rent stabilization provides a way for people to be able to be safe and in their homes for a long time in a rent situation. Also, a lot of seniors and disabled people are in rent-stabilized buildings for a long time, are able to be safe and secure that on their fixed income, on their low income, or with their medical circumstances, they have a good quality of residential life. The city has 5 core values. Quality of residential life is one of them, and it drives the policy that is foundational to the rent stabilization ordinance. So Gail, would you tell us a little bit about being on the commission and these 2 cases? How many people have read the cases, by the way? That's fantastic, thank you.
All right, my microphone is working great. Just to backtrack a little bit, I wanted to remind you that West Hollywood provides 3 kinds of protections to tenants through its rent stabilization ordinance. One of them is that rent increases are regulated. No more raising your rent 5 times a year, no more raising it by whatever amount is the whim of the landlord or what they believe the market will bear. Once you move into a unit, the rent that you agree to pay becomes, if you're in a rent stabilized unit, it becomes the maximum allowable rent, and then the landlord is allowed to raise that rent once a year by a particular formula that's based on the consumer price index for the area. A second service that's provided by the rent stabilization ordinance is that the landlords are required to maintain in your unit and in the common area the services and amenities that were provided when you moved in. The concept is you agreed to a certain rent, and that was to take care of, that rent was to pay for all of these amenities and services. So if you had an air conditioner that worked when you moved in, and at some point that air conditioner stops working, then the landlord is not maintaining one of the amenities, and you can then seek to have a reduction in your rent that's considered to be commensurate with the loss of service that you have suffered. And the kinds of housing services are varied. There are such things as having a stove, a refrigerator, a microwave, air conditioner, heater, garbage pickup, janitor service, having a yard, having a gardener, having a swimming pool, on-site parking, or storage on-site. There are many more. We've seen some very unusual issues before us about things that people regarded to be a housing service. One of them was a tree outside her window that gave her a sense of privacy. So, you know, it's one of those ever-evolving concepts. The third thing is that protection for tenants is that certain maintenance standards have to be met. Every 4 years, you're entitled to have your unit painted. Every 7 years, if you've got carpeting, it should be replaced, or drapes, linoleum, vinyl floors, and wallpaper. Every 7 years, those should be replaced if replacement is needed. That, of course, is always a question of fact that's decided at the hearing. And you have to, the landlord has to maintain your building and unit in accordance with applicable building, housing, and health codes. Okay, now coming to the administrative process. Let's say that your landlord has removed one or more of the housing services that you had, that you were paying rent in order to have. You can start the process by sending a letter to the landlord and saying, I want you to restore this service in the next 30 days. If you don't get some kind of response from the landlord that indicates that a willingness to take care of that problem, if they just say no or they take no steps, then you can file for a hearing. The hearings are an administrative process. This is not done in courts, but it's done in a similar way, although less informally. At the hearing, there is a hearing examiner who is an attorney who serves as an independent hearing examiner for the city. Both of the parties will attend the hearing. You will both be sworn in under oath. You can testify, you can present evidence, you can bring witnesses with you. You will be given a full opportunity to present your case, and the hearing examiner, knowing that a lot of times you're not represented by counsel. Sometimes landlords are, more often than tenants. But because if you're not represented by counsel, the hearing examiner will go out of her way to ask you questions and let you ask each other questions to get everything necessary into the record. This is tape recorded, and it's going to become the basis for the hearing examiner's written decision. So she's going to tell in her written decision what each party testified to, the written evidence they submitted. They're going to be copies of the written evidence maintained, and this becomes the record. Within 30 days after the hearing, she'll issue a written ruling. Somebody is maybe going to not like this ruling. Sometimes both parties don't like it because you can have a lot of issues in dispute, and they can be decided. Some can be decided for the landlord, some can be decided for the tenant. But if someone decides to appeal, then they will file an appeal, and they will have to say what the grounds are. And this is not going to. The appeal is not a new hearing. They're not going to go through the whole thing again. The question in an appeal is, did the hearing examiner make an incorrect decision? Did she make a mistake? And there are, if I could go back before we do this, because I need to give you this information when I tell you actually how those cases turned out. The factors that the hearing examiner can consider when she decides how much to decrease rent for the loss of a particular housing service. She can consider the extent to which the reduction in housing service affects the tenant, the relative significance of the reduced service in relation to the safety, health, convenience, and comfort of the tenant, the prevailing market value of the housing service in question as a rental amenity, the extent to which the tenant was led to rely upon the fact that the service would be provided, and such other factors as are deemed to be relevant by the hearing examiner or the commission. And the hearing examiner and commission also have a list of valuation guidelines that are not, you're not required to impose those, but they're just guidelines that you can be referred to. So the appeals process begins with the filing of an appeal in which there are just limited grounds. Because as I said, we're not trying the case over again. Nobody's going to come and testify again. This is going to be a question of, did the hearing examiner get it wrong? So the grounds are for an appeal. The hearing examiner's determination is clearly in error. That's like, you look at it, you look at what the facts were, this was wrong. Number two, the hearing examiner's determination is not reasonably supported by the findings that the hearing examiner made in her report, or it's not reasonably supported by the evidence that's in the hearing record. Third is the hearing examiner's determination constitutes an abuse of discretion. Now, she does have a certain amount of discretion. I keep saying she because the hearing examiner we have right now is a woman. Abuse of discretion. And that's really a judgment call that the commission will be making. Or the hearing examiner's determination is contrary to specific provisions of the restabilization ordinance or state law. So those are the four grounds. So it's a limited, we're focusing now on limited questions. We're not going to second guess the hearing examiner. We're looking for, did she make a mistake? And there are 5 commissioners. Each of us is appointed by a member of the 5-member city council. We will first hear, at the hearing, we'll first hear from staff counsel who will read a report about the underlying hearing, what is actually on appeal, and a recommendation. The 2 cases that you were given each of them contains staff counsel's analysis and recommendations. What you are missing in your packets that we have when a case comes before us is the underlying record. We're going to see all the evidence that was presented. We're going to have the hearing examiner's actual decision, which is usually pretty lengthy and really goes into the details of what each party testified to. You don't have that. You've got what the staff counsel, how she analyzed it, or he analyzed it, and how she or he recommended that the commission rule. And the other thing you have is how we ultimately ruled. Because at the end, we listened to the 2 parties. They come before us, each has 5 minutes to argue their case. We won't listen to any new evidence. It's based on record. This is an appeal. We're talking about, given the evidence that was before the hearing examiner at the time of the hearing, did she get it wrong? So we're not going to listen to new evidence unless they can prove to us that this was evidence that if they exercised reasonable diligence in trying to get it before us, that they did exercise reasonable diligence, but they couldn't do it. You know, something stood in the way. You know, and then we always try to adjust. But that rarely happens. People just forget to introduce things. After the 2 parties, the landlord and the tenant, have presented their argument to us, we close that oral argument and we begin to talk to each other about how we see the case, how we interpret the issue on appeal in relation to the underlying evidence, and what our opinion is as to whether or not the hearing examiner made a mistake. After full discussion, somebody will make a motion to adopt a certain resolution, either upholding the hearing examiner, overturning the hearing examiner, or modifying the ruling of the hearing examiner. And then we'll take a vote, majority wins, and subsequently, at the next meeting, we will have a resolution that we will then adopt. So now I'd like to talk to you about those two matters that you have had. The backyard. So the owner of a property that had a house in front and 3 rental units in the back and had a beautiful green grassy yard in between, decided after a number of years that his daughter was going to live in the house and he was going to fence off that backyard that those 3 tenants had been enjoying, and it would become the private backyard of his daughter who was going to live in the front. The tenants brought an appeal before us. They had a hearing first. At the hearing examiner gave all 3 of them a $40 decrease in rent for the loss of the yard. One of the 3 filed an appeal because he felt that he was entitled to a larger decrease because in the first place he had lived this. You don't have this because this is actually in the underlying hearing, but he had lived very close by, but he decided to move to this unit because he wanted to have that yard. He was a guy who loved to entertain outdoors. He told the landlord when he moved in, I'm giving up this other place because I am so in love with this yard. He moved in, years went by. He put furniture in the yard. He submitted photographs of the furniture. He had parties outside. He barbecued. He had friends over. He entertained outside. It was a huge part of his social life. Lots of photographs introduced. And then he also argued on the appeal level that he had also used a portion of the yard to store things. He had to put some Rubbermaid containers out there, and he was storing various things. And that now he wanted to be compensated for the cost that he had to incur to actually store those things elsewhere. The other 2 tenants, by the way, didn't use the yard extensively. In fact, one testified she rarely used it, but of course they both enjoyed the view of the yard. It was very attractive, and they enjoyed the idea that it was there if they wanted to use it. The hearing examiner gave all 3 tenants, the same $40 decrease, and her reasoning was that she said that the common area backyard has a value that applies equally to each unit, regardless of whether one tenant may be more inconvenienced by the loss than another. And she said that the RSO, the Rent Stabilization Ordinance, needs to be applied consistently. So at this point, when the hearing, when all of the argument was over, the commission began to discuss. And we agreed on 2 things. The tenant had not raised the issue of the loss of storage at the hearing below, so we couldn't consider that. Now, loss of storage is something that's compensable, but he didn't raise it at the hearing below, so it wasn't before us now. That's something that maybe he could raise it another time, but not now. And his request for monetary damages, I'm now having to store this and it's costing me money. We don't have jurisdiction to grant that. The only thing we can grant is a reduction in your rent that's commensurate with the housing service you lost. If you have a claim for damages, you have to go to court for that. Then we came down to a dispute between the council. Some thought that the hearing examiner, that it made total sense for her to say that everybody should get the same amount, it's the same yard, they're all tenants, it should be, the statute should be applied consistently, and others have said, we didn't see any reference to any section in the code that says that it has to be applied equally and that it doesn't matter if one person got more, that it was a greater inconvenience to them to lose it, or if they had, if they had relied on its being there more intensely than the other tenants. We thought that, if you don't cite authority, why should that be the rule? In fact, that's some of the things you can take into consideration. And that we felt that he should indeed have had, should be entitled to a larger increase than the other tenants, and we thought that it should be sent back to the hearing examiner to reevaluate how much each tenant should receive. We ended up taking a vote, and the hearing examiner was, her ruling was affirmed. We dissenters lost. So that's how that one went. It was, I'm not sure if I got somebody to go with me on that. I don't know whether it was 4-1 or 3-2. I might have had someone who went with me. Did I? So now, the storage question. Oh, by the way, if those of you, did any of you, how many of you thought that the hearing examiner should be affirmed when you evaluated that case? How many of you thought that tenant should have gotten a greater decrease? Yes! Yes! My God, if my co-commissioners had been as smart as you. Yes. Okay. Now we go to the garage storage. And see, you guys did that without some of the information that we had. Very cool. Garage storage. 2 tenants filed for a rent reduction when their landlord tore down a dilapidated garage that they were using to store a few boxes of items. You didn't know that, right? That it was still how dilapidated it was? I don't know. And that they were just storing a few things in there. Why were they storing a few? Because it leaked so badly in there that whenever it rained, you could only put boxes in certain places that wouldn't get wet. So anyway, the landlord finally tore down this pathetic garage because it really was so unsafe that you couldn't put a car in it. And he thought, hey, I'll tear it down, I'll concrete this, I'll give my tenants some parking. They'll have some parking there, a little parking deck. Well, 2 of the tenants who had been storing a few items in the garage decided that they would ask for a rent reduction based on the loss of storage. And that is a housing amenity, and they were using it as a housing amenity. The hearing examiner, she calculated the amount of garage space just based on the length and width, because she knew they weren't storing very many things in there, and she felt too that considering the fact that they shared the storage space, it wasn't secure, anybody could get in, and because it leaked and it was in generally poor condition, she looked at the valuation guidelines, which I think the lowest guideline was around $40. And she thought, no, it's not even worth that. It's not worth that. So she gave them each a $10 decrease. And after we heard the argument, when we began to discuss, the commission was, once again, we were divided on this. Some commissioners, including me, believed that the hearing examiner's decision was reasonably supported by the evidence. The garage leaked, it wasn't secure, they actually used very little of the space, and multiple people were using it. So we thought, that's fine, she has discretion, and she didn't abuse that discretion. You're not required to go by the guidelines, they're just guidelines. But other commissioners felt that the argument made by the tenant that the height of the garage, as well as the width and length, should have been regarded, and that in fact, it should be looked at as that the tenants had the entire garage potentially to use as storage. So in fact, they should have been given an award commensurate with that size, which was huge for a storage size, and then just take away a little bit because it was leaky and shared and dilapidated. So they said, we think $40, the lower end of the storage spectrum, would be appropriate. We took a vote, they won. I was on the losing side again. I'm giving you two of my losers today. How many of you agreed with the $40 increase that was given? You did, okay. How many thought that we should have stayed with the $10 of the hearing examiner awarded? Once again, the majority wish you had been there. So thank you very much. That concludes my presentation, and I hope you got a little sense of how these matters are decided.
We've taken you through the foundational pieces of that rent relationship, how disputes can happen, how they can be resolved, and then the administrative process that the city has in its role. I want to mention there are 8 rent stabilized or rent-controlled jurisdictions in the state of California, 3 in Southern California and 5 up north. So each of them has a different process on this. This commission actually has quite a bit of power, because if their decision is disputed by the landlord or tenant, the landlord or tenant must then take it next to Superior Court. In the case of other boards and commissions the city has, those decisions, those commissions have, get appealed to the city council. So this is a administrative process that goes into a fully legal kind of court case. And very, 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 very few times does it go to a court case, not only for the expense, but by the time it's at this point, it's really been vetted pretty thoroughly, and the facts and the issues at hand are clear. So now we have time for questions. We have a roving microphone, and we held you off for a little bit, so I'll ask you to go first. Anybody?
Hi, my name is Tracy. Firstly, thank you. That was very interesting. With regards to the first case that you presented regarding the backyard, that's what I want to focus on. My first observation is, shouldn't have each one of those tenants' cases been treated separately based on their inconveniences and their circumstances, rather than treated as a whole unit? Because they're 3 individual people dealing with their own issues. And before you answer that, just quickly, the second one is, because maybe you can answer this together, if that third tenant that did make a lot of use of the backyard, if he had some kind of disability, and he had actually chosen that property based on the need of access to that backyard to work through whatever developmental programs he had to access, would that also play into it, the final decision? Because then that would actually be counterproductive in his production and whatever is needed in his therapy to progress.
I think that, yes, the needs of the individual tenant can be, and should be taken into consideration in a situation like this. That's why we were saying that tenant, because he had every reason to believe that the backyard was going to continue to be there. He had told the landlord, "This is why I'm here. This is why I'm renting this, and the extent of its use warranted a greater amount. If he had had a disability, that too would have counted in. But also addressing disabilities, I think, is something, talking about the effect of disabilities on these matters, Elizabeth can address more fully. Regarding the 3 tenants, I believe that they chose to have this heard together, but they all had the opportunity to testify at the hearing. Each one of them was testifying. It just happened that the hearing examiner's viewpoint was that for the consistency, a consistent application of the restabilization ordinance, that the value of the yard should be consistent for all 3. That was her perspective, and the majority of the commissioners agreed.
I think it's a fantastic question because the yard was in some way by the hearing examiner viewed as a common area to all 3, therefore an equal housing service. So if they each had a light bulb in the yard, then the light bulb went out for one, they would be differentiated, but they each had common access to the yard area. And the individualized use was likely presented in the hearing, and the hearing examiner did not weigh that to the extent that this commissioner believes it should have been. The disabled access issue would escalate it if it was presented in the hearing. It would escalate the imperative and the weight of the evidence, but also that tenant would have other avenues to retain that disabled access under reasonable accommodation law, which is separate from rent stabilization. It's a statewide law that came into play about 3 or 4 years ago. Did we get both answers here? Okay.
I was just going to comment too on the disabilities. That brings in a whole other area of law, because we started on a federal level all the way down to state level and so forth. We have American Disabilities Act here, which controls disabled access, and I think that's what Elizabeth was getting at. I think if that was an issue, and it sounds like it could have been in that circumstance, the way you described it, we have a whole set of other issues and other law that, yes, maybe the commission would have considered them, and then there's probably other avenues that the city would have looked at as well, and other legal recourse that tenant would have had for eliminating access for them that they're potentially legally entitled to.
Yeah, as a matter of fact, if the tenant had come to rent stabilization office to talk about this at the time of filing the original application for a hearing, it would that the disability aspects would have been addressed immediately.
Other question? Bring it back.
Was it?
With the first case, if the tenant were to have the approval of the other tenants, would they give him a larger rent decrease? Or would that be a situation that could possibly happen?
Well, one thing that could happen is the other tenants could have decided not to seek a decrease themselves. But that's, that doesn't happen very often when it's available. But actually, your question is a good question. I think, though, that given the viewpoint of the hearing examiner, that this was a common area, that they all had equal access to it. And
if the other tenants knew that he had moved into there specifically to use the yard, and that he had furniture in the yard, and that they themselves didn't really use the yard that much, and they said, okay, we're okay with that, would that be something that would happen?
I just don't know, and I don't know how the hearing examiner would treat that. Do you, Elizabeth?
Yes. What happens in that case is that all tenants who have stake in the common area have get a notice that they are entitled to that rent decrease. Tenants do not have to take that rent decrease, so if those tenants felt like it was not appropriate, then they would continue to pay the higher rent. That's what happens with it. Can the tenants make a deal amongst themselves? No, because as Mark outlined, it's a landlord-tenant relationship. not tenant to tenant. And by the way, if you do anything with roommates, call your local jurisdiction first. It is the messiest, most problematic thing outside of property maintenance and evictions. So, and also look at Berkeley's website because they have the Cal Berkeley, and they deal with a lot of student population. They have a lot of help there on roommate to roommate issues, in case you guys run into that. Next question.
I'll ask on the microphone. What is the danger if you go to, let's say, a comfortable landlord, unlike, for example, friends in New York, letters of referrals are necessary to rent. So
I'll ask the question again. So compared to New York, the fear is that if I get a conflict with my landlord, the problem is if I don't have a letter of referral, is it important in LA to have referrals just as in New York, or is that not necessarily an issue?
That's a really good question. I mean, sure, you deal with almost a business judgment decision you have to make. Look, of course, referrals are sometimes very important. I think it probably varies depending upon the kind of level of apartment that you're looking to rent, how much the landlord's going to really look for referrals or care about them, but you sure they're important. And do you look at whether you should make a complaint with a fear in the back of your mind that you won't get a referral? Of course, it's something you should consider. I think West Hollywood looks at that with sort of greater perspective and saying, we really want you to be taken care of as a tenant. And so they provide for these systems like this mediation, which aren't available elsewhere, to hopefully get these kinds of problems resolved in a more amicable way. So hopefully, I mean, do the parties walk out of these proceedings with both sides happy? Maybe, maybe not. I mean, in the law, we always say mediation and it's a compromise and nobody's happy. But on the other hand, there's probably a greater chance of people coming up with some sort of a mutually satisfactory solution. So I think that's one thing that, is good about jurisdictions about West Hollywood, like West Hollywood. I've dealt with it on the other side, sitting in the landlord-tenant court where you don't have any of these resources. And you've got tenants who are coming in, and there may be some pretty atrocious circumstances. And thank God they went to, sometimes you think, thank God they went to court, because you've got some pretty lousy landlords out there. Look, it's a judgment call you've got to make, but I think you should stand up for your rights, know what your rights are, and stand up for them. I mean, hopefully the next landlord will be smart enough to look at circumstances, and if you don't get a letter of referral, or if there is a problem, take a look at it and see what the background is involved in that situation.
Anybody else? You all satisfied? Well, then I want to thank the panelists very, very much for an interesting and illuminating discussion about issues that at some point in our lives will probably touch all of ours. Thank you very, very much.